Hey, hey, hey. How are you guys this morning? We got snow. We got snow. We got snow last night and this morning. Yes, we did. We did. We did. We got snow. So much snow. I thought we were supposed to get less than an inch. I don't know what we got out there, but we got some snow. It's a nice, pretty blanket of snow. It is 9:15. I don't see Mr. Tucker in his chair. The judge did say 9:15, right? Judge said 9:15 and he's not there. Good morning, good morning. Cynthia Bujak is here in the chat with us today. Oh, there he is. Wow. And it's 9:16 a.m. He's 1 minute late. 1 minute late. But good morning, Cynthia. Good to have you here, darling. Darling. Mickey Joe sitting in the corner, crocheting and drinking strong iced coffee. Well, I am drinking strong hot coffee. Oh, it's so good. So good. Cynthia says, first time I'm still up from last night. Oh my goodness. Wow. Nothing unusual. It's not unusual to be up all night. Doing the Carlton dance, you know. Good morning, all. I'll be in and out today. We have doctor's appointment. All right, JB's mama, no worries. Glad to have you here. Good morning. Good morning. The judge is actually the one that's late this morning, right? Hey, Henny, good morning or good afternoon to you in the Netherlands. Hey, Miss Tammy. Tammy just woke up. Cynthia says last night and this morning I can hardly hear you. Oh, you can hardly hear me? Hold on a minute. Let me make sure I have my settings. Anybody else? Nobody else can hardly hear me? Tammy says she can hear loud and clear. Let me know if anybody else is having trouble hearing. You got me turned up, Cynthia? Tammy or Henny says all good.
All rise. Circuit Court of the 16th Circuit of the State of Florida is now in session.
Lord have mercy. That blew my eardrums out.
Morning.
State versus Tucker. Prosecutor is defendant. Everybody else is here. So,
It was loud, Tammy. I know, right?
what we planned on this morning was to hear the defendant's motion for judgment of acquittal and then to address the logistics as to the Zoom testimony of Ms. Belmonte. So,
Jump scare, right?
Tucker, are you ready to be heard on your motion for judgment of acquittal?
Yes, sir.
Okay, well, you can proceed.
And about approximately how long do I have here, sir?
Well, how long do you need?
I'm not sure.
Well, I can't imagine more than 15 minutes would be necessary, but
Yeah, those acquittal things are like always super short and sweet, to the point.
Okay. All right.
Apparently, you guys, the jury isn't supposed to be in till 1 o'clock today.
Wrote a motion.
And No.
For a second there. Actually, I've been writing it anyway. I had a completely different one at first. But, you know, Your Honor, let me take off my glasses. I want to be respectful here.
Oh my God.
All right, there we go. And I can even read a little bit easier. Your Honor, this case has been going on for 6 years. It wasn't good at the beginning, not good now. You know, as far as being able to have the prosecution be able to prove their case beyond a reasonable doubt, okay?
But that's not the standard. Just so we're clear, that's not the standard for a motion for judgment of acquittal.
I don't know. From what I read last night from the Florida, you know, when I was reading Florida, was it the criminal code? Was it criminal rules of procedure, or criminal code of procedure, whatever? Literally, it was okay if you don't think there is enough evidence for the state's case to sustain a conviction of reasonable doubt.
No, that's not it.
Well, then go ahead and explain. I would
It might
appreciate
be
it.
a little high standard after the close of all the evidence, but basically, has the state put on a prima facie case as to each element of the charges that have been brought? That's the standard, looking at the evidence in the light most favorable to the state.
Right. And looking at the evidence most favorable to the state, it hasn't gotten any better over the years. And I'm looking at it now because I've been looking at it for 6 years, and it's always been the same. Now, the thing is even, okay, all the evidence the state presented, the only thing they had was Travis Johnson. That's it. We knew that was going to be the case. And even then, even at his best, his credibility is doubtful, right? So, okay, that's the case. But even then, if you actually compare it to the other witnesses they put on and the other evidence in the case, they still haven't even come up with a concrete narrative. Okay, they put on Roger Ruggett, who says he was attacked by 2 men, skull masks, both carrying knives. State then puts Travis Johnson on, who says knife, pipe, skull mask, and a Jägermeister neck gaiter. Those two aren't consistent. They can't even get a consistent story here. So to think that the jury is going to be able to ever come anywhere close to a verdict of beyond
Good
reasonable
morning,
doubt,
Dawn. Good morning, honey. How are you today?
I don't see it.
How are
And I
you
mean,
this morning?
Again, I can go through the rest.
Issue, Mr. Tucker.
Okay.
I mean, I'd hate to keep
Okay.
beating on the same drum,
Well,
but your
I mean,
argument
Okay,
is
well, I
not
won't argue that anymore.
on point with
Okay.
the law.
Your Honor, there's been a lot of things in this case that have been on the point with the law.
Well, I disagree, seeing that I've been the presiding judge and feel that the rulings I've made have been consistent with the law. You're certainly entitled to disagree with that, but right now
Your
we're
Honor,
focusing
Your
on a
Honor.
very narrow question. All this other stuff is not the point. It's, have they presented a prima facie case? That's the question.
Okay, Your Honor, and again, I'm trying to be as respectful as I
I
possibly can.
understand that, and
Okay.
I'm not construing it as disrespect. I'm
good.
trying to direct the argument to the issue.
Okay, well, the issue has been there for a long time, Your Honor.
I don't understand that
to be
point
quite
at
frank,
all. This is the first time we've been in trial, so.
No, but this case should have been dismissed due to the
That's
misconduct on it a long
completely-
time ago.
That's
A long
completely
time ago.
irrelevant. It has nothing to do with what we're doing
Honor.
right now.
Your Honor,
Yes, sir.
my due process rights have been violated the entire time. The entire time.
Okay, sir. You want to
I'm
just
telling
some
it the
sort
way-
of
look, I'm telling
inflammatory
the truth.
rhetoric? If that's
I'm
how you
telling
want
the
to spend
truth.
your 15 minutes, go
Your
ahead.
Honor, okay. Again, how about setting me up with Naeem Jackson? The 3 officers admitted to doing it, and you're saying it didn't happen? That
Sir, what does it
violated
have
4
to
of
do
my
with a
constitutional
judgment,
rights.
a motion for judgment of acquittal? Absolutely nothing.
No, it meant that you should have.
Mr. Jackson.
You should have dismissed the case. You should have dismissed the case according to the Constitution of the state of Florida, which says, if my due process rights have been violated, that you are bound to dismiss the case. And that violated 4 of my constitutional rights right there, and that was only 1 incident. 1. And we have proof of many. And yet you haven't investigated it. You've just denied it.
Sir, I am not an investigative body, so, again, you want to...
I shouldn't be in this courtroom, sir. That's
Very subjective perspective.
I mean,
Anyway,
look,
if you're not going to make a relevant argument,
I
you
will
might
make a
just
very
wanna sit
relevant
down.
argument. I will make a very relevant argument,
Okay,
sir.
well, I haven't heard.
And I think I've
any-
made one so far.
I haven't heard it yet.
Well, I'm sure, because you also, again, denied the misconduct that was committed. And we know it did, we know it happened. It wasn't a question. We know it happened. But the state, they deny it, you deny it, and it doesn't exist. We know it happened. It's not a matter of if. I mean, again, we had so much evidence, it wasn't even funny. How much evidence do you have to have? But yet, here I am. And to be respectful, Your Honor, you chastised me for being late yesterday, right? And wasting everybody's time.
And the day before. and the
Okay,
day-
well, and here's the thing, is when we filed that motion to dismiss, you had your option not to be here at all and not waste anybody's time.
Judge, I want to object.
Yeah, I'm going to sustain it. That's irrelevant. So anyway,
Again, we made the case for many acts of misconduct, Your Honor.
Objection.
sustain.
I didn't know they got a say in this. I
Sure
wasn't
they do. When somebody's standing up here making irrelevant,
Okay.
inflammatory, specious
Okay.
arguments, they have a right to object.
Well, again, I mean,
I
sure.
thought you were making a motion for judgment with
Well, the
acquittal.
motion for judgment, we both know you're going to deny anyway, right? I knew that before I even came up here. Just like I knew how this was going to go. Everybody wants to know why I went pro se.
Objection, irrelevant argument.
Yeah,
know?
I mean, yeah, but
I mean-
guess Mr. Tucker just wants to let off some steam. Let him go ahead.
No, it's not,
I mean,
it's not a matter of letting off steam, Your Honor. It's a matter of telling the truth and trying to get the truth
sir,
out.
This isn't the soapbox on a street corner. This is a court of law where we make arguments relevant to the issues. But as I
Okay.
said, if you want to, play up to the cameras or
Well, no, you're trying to say that you're doing
let
this
off
with,
some steam, go ahead.
Your Honor, you're trying to say you're doing this within the law and within the rules. The rules said that my case should have been dismissed. That's what it says.
That's what you think, sir.
Now, that's what I have evidence to
I'm not
prove.
surprised that from your subjective perspective, you think you shouldn't be. That's 99% of the defendants feel that way.
Okay,
So
well, I'm
that's
sure they
not
do.
Unusual. So in any event,
I'm sure they do, but how many of them have evidence that they were set up in jail with a CI to try and
I
give
didn't
them?
hear that evidence in court. I haven't
We
heard
tried to bring
that,
it.
Mr. Jackson.
We brought it in many times. How many times we bring up Mr.
Sir,
Jackson?
this is the trial. This isn't some pretrial motion. We haven't heard anything from Mr. Jackson or statements from you at all.
Your Honor, look, I've studied this case for 6 years. I've studied the law a little bit. I'm not as good as anybody in here, I guarantee you that. But one thing I've learned a few things. One, the state attorney's office has a bound duty according to the bar, to investigate any acts of misconduct that are not considered frivolous. And I don't think 3 officers who admitted to doing it is frivolous. But did they investigate? No. They decided to take me to trial. Right? Is that how justice goes? That's how the law works? I don't understand. Again, I'm playing by the rules, right? I'm playing by the rules. Trying to anyway. I didn't do anything to ask for this. I didn't want this. We tried to file a motion to dismiss, and then, again, everybody's acted ethically. That's what you said. That's completely untrue, but that's what you
Everybody
said.
what? I'm sorry. What?
Everybody, the state attorney's office has acted ethically the entire time, and so is the court has acted ethically the entire time. Is that correct?
Judge, I'm going to object. This is improper jail.
Yeah, I'm going to sustain it.
Okay.
I don't know what every word in that order said, but I'm sure there was reference to that. But again, it's not relevant to.
Well, I mean, you guys wrote it off as conspiracy theories and personal attacks when we had a mountain of evidence. Nobody wanted to hear it.
Again, I'm going to ask you to sit down if you don't want to argue your motion,
Okay.
because so far you haven't really argued a motion
I mean-
for judgment of acquittal.
Well, okay. And at this point, I'm going to go ahead. I'll go ahead and give you my points on the case then, as it stands now, right? Okay, let's go over Miss Jenna Mueller.
Use the first 5 minutes of your 15,
Perfect.
so in any
Perfect.
event.
That means I have 10 more, correct?
Yes, sir.
Okay. Jenna Mueller, offered all kinds of evidence about this crime scene. She offered evidence about, her being a first responder. Did she offer any evidence about me? No, 0. Right, that's none. Okay, so let's go to the next witness. That would be Roger Ruggett, right? Roger Ruggett, he didn't offer any testimony against me, Matter of fact, he kind of helped me with the whole, he didn't know my name, but again, in the affidavit, it was, completely opposite. It stated that he actually made statements saying it was me. But then again, that's irrelevant. Let's go ahead and go to the next one. So Roger Ruggett doesn't offer any evidence against me. 0. Right, let's keep on going down. Let's see who we got for the witnesses. Let's see, after that we got Marcus DeVal. Marcus DeVal doesn't offer any evidence against me. 0. Right? Let's keep on going from there. Let's see, and there's a good reason why there's 0 evidence, by the way, except for anybody that can be basically bribed to testify. So let's see what else we got here. Let's see, inconsistent. We got Jenna Mueller, we got Roger Ruggett. Keep going down. Let's see, we have, DeVal, no. David Fernandez doesn't offer any evidence against me, 0. Right, again, except for the video, he explains that you can't see anybody in. Okay, so we're, keep on going down. But he did admit that you can't see a getaway driver in that video. He did admit that. Then we go to Danielle Malone. That's a whole another interesting one there. Because of course, she made false statements about when I actually became a suspect to avoid the whole Penny Phelps thing, which of course that's why she's not here. Let's go ahead and we'll keep on going down. Cosmo videos, nothing there. She did say that Wilson and Johnson made statements against me, and that was her evidence that was me in the videos, right? Wilson has since, at trial, said that he was coerced into making those statements. Johnson also said he was coerced into making those statements when he filed his motion to suppress. So both of those people said their statements about me were untrue at different points. So, okay.
For the record, I'm objecting. Those are facts, not in evidence in this trial.
It's sustained.
Well, no, you're wrong. I'm just wondering, again, facts. It's fine.
Not in evidence.
Well, let's see. We'll keep on going. And then, the whole thing with Miss Paula Belmont. Miss Paula Belmont's been saying it wasn't me since the beginning. Since the beginning. Now, and the thing is while you can hammer me all you want, again, she's the victim here. Her, Matt, Roger Ruggett, the people who were actually victimized that day. That's what we're supposed to be here for, right? That's what this is all about.
No, it's about the trial in the case of State versus Tucker.
I understand that, but why am I on trial? I'm on trial because those
You're
victims
accused of 4 crimes at this point.
Right, and those victims, and again, I'm accused of 4 crimes. That's true. I've been accused of more, apparently, when we started this. Let's see, and I can tell you when I actually was named a suspect, because that's been, again, that one was actually put on the stand too. Let's see. So, okay, nothing really, man, from Danielle Malone, except for that she says that, was it Travis Johnson's statements or, something that should be believed, I guess. Same thing with, again, she brought out Rory Wilson, who's not even going to testify, so, it's hearsay, it doesn't matter. Let's see, let's keep going down. And the state, we go to, okay, now we go to Travis Johnson, who the state says is consistent. Again, he's wavered on this story plenty of times. While I did poke quite a few holes in his story there, the bigger one is the inconsistencies with the rest of the witnesses and evidence. He keeps trying to put the knife in my hand. There is no evidence that the knife was ever in my hand other than what he says. The DNA evidence, again, says otherwise. Not only that, the state now is trying to use that same weapon, and put it in two different people's hands. They literally convicted Rory Wilson with that knife. And now, all of a sudden, it's my knife? Okay. Let's keep on going here.
This is a felony, it's a felony murder charge.
I understand what a felony murder charge is. I understand that, Your Honor.
Well, what you just said.
But I mean, okay, why would the state keep trying to put the knife in my hand and say that that's consistent with the evidence? It's not. It's not. It's not a consistent statement. It doesn't match the DNA. It doesn't match the conviction they just got against Rory Wilson. I mean, do you keep on using the same murder weapon and keep on handing it off to people? You know, I don't know. But okay, so let's keep on going here. So, okay, John Travis Johnson's statements again, like I said, the masks. Again, he says, was it a skull mask and a neck gaiter? Roger Ruggett and every other witness says skull masks. Nobody ever once, except John Travis Johnson, says a neck gaiter with Jägermeister all over it. He's the only one. But we're supposed to believe him, the guy who is getting 5 years instead of a life sentence. The jury's supposed to believe him, right? So, okay. So that, you know, again, we got John Travis Johnson. Now, what do we have after John Travis Johnson? We have the ME. ME didn't say anything that meant, you know, that actually implicates me. Then we have the DNA analyst, who I was actually calling as my witness. Because, again, no DNA evidence. And even the ones that the prosecutor tried to say is, you know, again, he was trying to use inconclusive as positive results, right, as the same thing, but they're not. And then,
didn't hear that.
I did.
That they're trying to use inconclusive as positive.
Well, I mean, what else are they going to use? What else are they going to use? There's nothing. They knew there was nothing there. They knew that, man, 2019. So, okay. So nothing in the DNA, right? So we have one witness, which is exactly what we knew it was going to come down to, John Travis Johnson. The rest of the case is fodder. That's all it is.
It's what?
Fodder, you know, smoke mirrors, you know, that kind of thing.
Oh, I know what fodder
Okay,
is.
so that's it. We come down to John Travis Johnson. John Travis Johnson, again, like I said, his credibility is shaky at best, and with the outbursts he had up there on the stand, you know, Lord knows, I thought he was going to jump off the stand and come after me the first time, you know. So that whole sweet, innocent getaway driver thing, that they have no proof that he's the getaway driver, but they love saying it, might as well be his last name now, you know. But okay, so I'm supposed to, again, risk my life with these 12 people, you know, risk my life on what? The evidence the state has is John Travis Johnson. That's it. Now, we have, again, we can keep on, again, just some of the same things I just named. No DNA on my side. Zero. Right? And even some of the things they named as inconclusive weren't ever even actually evidence. They weren't, man, found at the TREEHOUSE site. They weren't actually, you know, they didn't have any victims' blood on them. They actually had nothing to do with the crime. As far as the gloves, the shirt, that kind of stuff. That's why they're not in evidence now, right? But they said, you know, okay, well, why don't you tell us everything that was inconclusive? That's why I meant by they're using it as a positive, Your Honor. That's why I asked prior to them coming up here and asking questions, that those inconclusives not be allowed. Because I knew they would use them as a positive. Now, that's the case. That's the state's case. They rested on that. That's what they have against me. That's what cost me 6 years of my life. That's what's going to cost me the rest of my life, maybe. You know, and that's insane. The state can bring somebody to trial on that. That's insane. Now, again, I don't expect you to give me a judgment of acquittal. I didn't think you would, and I don't. You know, and so I've been fully prepared, you know, for the next, to move on to Miss Belmont, which again, I have the surviving victim saying she's 100% sure. She's willing to risk her life that she almost lost that night on the fact that I'm innocent. That's what she said in an interview.
Risk her life, sir?
That's what she actually said in an interview, Your Honor. She actually said that to the media. She said she was willing to wager her life that she almost lost that night.
You know, we're certainly going to give you an opportunity to present that testimony. It's not part of the evidence in the state's case, so it's not relevant to the argument.
Do I have any time left, Your Honor?
You got a minute.
Okay, good. I'd like to say one more thing, because it really did upset me. When I came in here the other day and you were upset with me, and I understand that. You know, I understand you being upset with me.
Judge, I'm going to object. This is improper jail.
What does he want to say? I guess it's
I understand you being upset with me, but Miss Paul Belmont is sick, very sick, and she wants to testify. That's all she wanted. That's all she wanted. And she's the victim in the case.
Yeah, so she's going to testify.
No, but she has the right, again, what if she had died?
Is this a rehearing on
I'm just saying, what if she had
not
died?
to take it out of order? I've already made that decision. So in any event.
Personally, I think you made that decision because you were mad at me.
Okay, sir, you're entitled to your personal opinion. That's fine. I don't expect you to agree with me. I don't. So you
I
think
get
whatever
that.
you want to think, and
I
that's
get that.
fine.
I get that, Your Honor. And look, again, I'm going to prepare for my next, I'll prepare to call my witness, Your Honor.
Okay. State.
Judge, the state has proven a prima facie case as to each and every element of the crimes charged against this defendant. If the jury believes the evidence that's been put forward, the state has proven first and foremost that the defendant, along with the co-defendants, Rory Wilson and Travis Johnson, conspired to commit a robbery at the Treehouse on November 17th of 2017. Their motivation was to get some drugs and money, and they put together this plan, and they effectuated that plan. Travis Johnson gave us the details of that planning, and actually the details of the overall execution of that plan. This defendant is alleged, and the state submits has proven, this defendant, along with Rory Wilson, approached the Treehouse that night after having been driven over there by Travis Johnson. They went inside the Treehouse and they attacked Paula Belmonte and Roger Raggett. Roger Raggett testified that these two masked men came up the stairs. He was non-specific about the mask that the second man was wearing, and that would be the man that pounced on him. When Mr. Tucker questioned him about the height of that man, it was very telling because Mr. Tucker put his hand way up here in the air, and Mr. Raggett said, no, lower than that, lower than that. And then he finished by saying, about your height, was the description he gave of the second man. He proceeded to articulate what happened inside that Treehouse, the fact that that he was being beaten and Paula was being stabbed by the other man. And at the end of the day, they grabbed the tin that was on the table and the bag and they left. He also describes that Matthew Bonnett came upstairs, saw what was happening, and ran back down the stairs.
Excuse me.
At the end of this, whatever was happening inside the Treehouse, we have Travis Johnson testifying that he looks and he sees first a man running out of the Treehouse screaming for help, and then he sees a man dressed all in black that he said was Tyrone Tucker running out of the Treehouse carrying a bag that he carried back to the warehouse. They get back to the warehouse, the spoils of the robbery are shared by the three of them. They smoke the dope that they got. Under the felony murder rule, first-degree felony murder, all three are guilty of the
Objection, Your
crime.
Honor.
Well, I'm sorry, what's the objection?
The objection is he just told a bunch of stuff that wasn't true. I mean, if it is true, that means John Jarvis Johnson was in the house.
Again, Mr. Tucker, you're demonstrating your fundamental misunderstanding of this phase of the proceeding.
I guess.
Yes, you are. The state is presenting the evidence that's been presented in the light most
Your Honor.
favorable, sir, to the non-moving party. So you can disagree with it. You can challenge
actually
it, but in terms of an accurate recitation of the evidence presented,
It wasn't.
it's not distorted. So I'm going to overrule the objection.
Your Honor, can I at least explain what I
No,
thought?
no.
Good
you
morning,
can't,
Kel.
because
Good
you're not
morning. Happy
understanding
Friday.
this phase of the proceedings.
Okay. Okay, Your Honor.
Judge, under the first-degree felony murder rule, all three are guilty of the crimes that each committed during the course of this robbery. Under the principal theory. Under the first-degree felony murder rule, they are guilty of murder because Matthew Bonnett ended up being stabbed and killed during the commission of this robbery. The state has proven each and every one of the elements of that crime against this defendant. This defendant is also charged with robbery with a deadly weapon while masked. And that's of Paula Belmonte. Again, this defendant, under the principal theory, is aligned with Corey Wilson and Travis Johnson at this point. Corey Wilson is the one that's alleged to have attacked Paula Belmonte, but at any rate, it doesn't matter.
Kel, just to catch you up real quick, the first thing they're doing this morning is Tucker is doing his motion for judgment of acquittal. And yeah, you should rewind it and watch it back because it got hot and heavy. Yeah, watch it back. It's pretty good. Um, and let me see. Um, I agree, Tammy. I don't. I mean, I feel like the judge is just trying to explain to him how this part of the, he said this isn't, how this part of the process goes. Like he said you're like fundamentally not understanding how this part of the process is supposed to work. And he doesn't, obviously, but yeah. He should have kept a lawyer. He should have kept his lawyer.
Matter because they're all guilty of everything that happened inside that treehouse that night. So this defendant is guilty of the attack on Paula Belmonte, which is count 1 in the information, robbery with a deadly weapon while masked. This defendant is guilty of count 2, aggravated assault with a deadly weapon against Roger Raggett. Roger Raggett was very specific about seeing this guy come up and raise the weapon up in his face, put him in fear of being stabbed. Roger Raggett was also the victim of a battery by somebody who was masked because Roger Raggett continued to testify that he was beaten by the man that approached him in this attack at the treehouse. At the end of the day, Judge, the state has proven a prima facie case against this defendant as to each and every element, and the state would request the court to deny the motion for a judgment of acquittal.
Okay, thank you. Did you want to have a minute or two rebuttal, or?
Yes, sir. Actually, that was why I objected. When you said his case, the case as he recited actually matched the evidence, he just said that John Travis Johnson described taking the tin, taking the bag, and being in the house. He literally just said that. So if he was in the house, how's he the getaway driver?
Anything else?
Well, Your Honor, again, if his prima facie case is based on, again, on the testimony of Travis Johnson, and he supposedly, again, he knows all that stuff because he was there, that makes sense. He can definitely recite all that stuff, and if he can recite what happened in the house, which is what you just said, that means he was in the house.
All right, thank you. Anyway, I've been presiding over this case for many years now, and throughout this trial as well. I've heard the defendant's motion for judgment of acquittal. I also heard many extraneous points and grievances and irrelevant matters, tried to be liberal, and as I said, let the defendant let off a little steam. And those issues, other than the question is whether the state has presented a prima facie case, that is, evidence on each element of the 4 crimes charged: the felony murder, the robbery with a deadly weapon while masked, the battery while masked, that's in count 3, an aggravated assault with a deadly weapon while masked. That's the issue here, taking the evidence in the light most favorable to the state, the non-moving party. That's the standard of review, and irrespective of Mr. Tucker's, says he doesn't want to be disrespectful, but by claiming that I've already made up my mind, it's very disrespectful, but it's, doesn't faze me at this particular point because he's inflamed with his own self-interest, and I get that. So the point is, you're trying to distill the state's evidence to Johnson in and of himself is inaccurate. He's, I would suggest the main witness for the state, but there is corroboration of his testimony in various regards. You certainly have matters to argue to the jury. That's not the issue right now. The issue is, have they presented a prima facie case? And they have, as to each of the offenses charged, so I'm going to deny the motion. So, next step is, what do we need to do to effectuate the testimony of Ms. Belmonte via Zoom? Do we have some technical matters? Have we got the location of her room? Have we got the person from the state designated?
Yes, sir. Our investigator will be out there at noon today. We know what room number she's in. He'll be there to protect our interests, I guess, in what's going on out there.
Well, when you say protect your interest, I take it this person's going to do nothing more than be present and observe.
Correct.
Nothing more in terms of setting up equipment, in terms of asking questions, in terms of just to observe.
Correct, Judge. Just to observe, and he's one of the investigators that the defendant had requested that we use. So Ms. Belmonte, I guess, knows this investigator and is comfortable with him, and that's who we're going to use.
Thank you.
Okay, so she have a means to?
Yes, Your Honor. I set her up with a laptop this morning, had Zoom on there. All she has to do is hit the microphone, hit the video. I just need an email or, something for the screen over here so that we can go ahead and link in. That's about it. The only thing I would suggest for the investigators, there is her caregiver is going to be there to help them. They're going to need was it the full body suit if they're going to be in there.
Okay.
Judge, I would propose that we log her in right now and get her up on the Zoom and see if it's working.
I actually had it set for 12:30 so we could do a half-hour test, like just beforehand, just to make sure we're okay for 1 o'clock.
So, again, I certainly am ignorant about the logistics of this, so it's going to be, Mr. Alvarez, yesterday you were talking about your cell phone, so there's something more direct that the...
Judge, my understanding, and again, my knowledge of this area is limited, just like yours is.
Mm-hmm.
But in the past, some of these Zoom hearings I've attended, I have the application on my phone. I'm able just to log in, put in the login information in the passcode if there's one, and that will connect me and remote me in. My understanding in what Mr. Tucker is saying, he's already provided Ms. Belmonte with a laptop, which you could also log in as well, and it's just a matter of connecting it here on the internet.
Yep. I also provided links to both the state attorneys so that they would.
So let's get Carrie in here. Could you help out with that, Deputy Riccio?
All right, so they're going to get their technical issues worked out, make sure everything's working. But yeah, the jury isn't supposed to be until like 1 o'clock.
Request for any kind of instruction before the testimony is presented about what it is, how it should be considered. If anybody, like the next witness is going to appear remotely via Zoom, you will be able to see her and hear her, but she is not going to be present in the courtroom. I don't know if anybody wants me to say that's because of health concerns, and you should consider her testimony the same as you would if she were in fact here in the courtroom. If someone wants that sort of instruction or explanation, fine. Usually, I would usually say something like that, usually in a civil case when we have a videotaped deposition, but, you all tell me.
That would be fine, Your Honor.
Carrie, we're going to have first defense witness testify by Zoom. She's over in the hospital, and I just wanted to try to get everything set up so when the jury gets here, it's as smooth as possible. So I don't know if this, she's got a laptop, if that would be directly here or I don't know. I'd prefer not to have anything to do with setting it up, but,
Well, someone will have to host the meeting. Is that going to be this?
I tell you what, we don't need to be on the record for this, so would you mind kind of liaisoning with the lawyers, and then when we've got it figured out, the deputy comes and gets me, and if you don't mind doing that. All right, so I'll be standing by.
It's not going to be recorded or not recorded, you said?
Well, I think we need to ask our court reporter.
Okay, so let's look at some of these comments and get caught up. Mickey said, what's this man accused of? He is accused of murder.
We just
He,
asked Monica what she thinks we need to do for the record. That's fine.
Yes, sir.
As long as I can hear when my video is presented, if there's a mic running up there, that'd be fine. I don't know how.
I can put this mic here, if no one's going to be using it, I can just lay it right
So
on this right.
they'll use that one, but we can probably get the TV to that one.
So, we're just working this stuff out. I'm going to mute the mic for a minute.
Wait, oh, Pam, am I just talking to you?
So which way?
Or at least turn it down some so it's not so in my face when I'm trying to talk to you guys. Okay, so the guy on the right, Mickey, his name is Franklin Tyrone Tucker, and he's charged with murder. Allegedly, him and two other guys were going to a location to steal some money and drugs. And when it happened, a man got stabbed and he died. And that's what he's on trial for murder for. He says he didn't have anything to do with it. And the other two guys say that he did. However, there's no evidence proving that he was there. The only evidence they really have is the testimony of one of the guys that was on stand yesterday and the day before that. So that's pretty much it in a nutshell. Kel says if Tucker was wearing the mask, his DNA should be on the inside of it regardless of if he was wearing gloves. Agreed. But Kel, the mask that they have, allegedly, is not the mask he was wearing. The mask that they had was a mask I think that Rory Wilson was wearing. This guy, Tucker, according to the Johnson guy that was on the stand yesterday, he says that Tucker didn't have on a mask. He had on a neck gaiter, like which one of those things that goes around your neck that you can pull up over your face like that. And he said it said Jägermeister all over it. Well, they never did even find that. Let's see. Tammy says what the prosecution is doing, Tucker tried to do the same, but he won't let him. Where's the evidence? Right, Tammy, there's no evidence. I'm not sure, Dawn. Dawn says it's been snowing. Here again, we're supposed to get 3 to 6 inches. I don't know how much we got here. We did get snow. I just don't know how much is out there, but it's a nice little amount. Tammy says the judge has made up his mind already. I just don't see no evidence finding him guilty. I don't either. Yep. No DNA. All of the DNA that they got, the witness yesterday said that it was inconclusive. Tammy, we got 5 inches the other day too. Wow, Dawn. You guys got a lot of snow. You guys got a lot of snow. Dale said today, whenever he gets home from work, he's going to take Kiddo out to play in it. So we'll see what she thinks of that. We really haven't had enough snow for her to play in. So we'll see what she thinks of it. Tammy says the snow has melted. I don't know what our temperatures are supposed to get up to. I have no idea. It looks like they got their stuff squared away. I mean, the Terry guy, I don't see him. Looks like both the parties are sitting at their respective desks or tables. I'm eager to see Miss Paula's testimony. Eager. I gotta get some chapstick. If Kel is still here, Kel, are you up for a crime time joke? Haven't seen Lee this morning either. Wonder where Lee is. Maybe Lee is sleeping in this morning. Maybe Lee sleeping in this morning. I have to find my little noise thing. Where did I have that at? Was it on this page? No, that's not it. Is it on here? No. I'm looking for where I hid my nope, that's not it either. Well, I'm gonna have to go find it. Let's see. Kel must not be here. She must be maybe on her way to work. Maybe on her way to work. I don't know where she ran off to. Okay, I found it. Hold on, let me make sure this is it. Let me mute my mic real quick. Okay, yeah, I found it. Yeah, Dawn, I will. I'll let her know. Thank you for that too. I talked to her a little bit in in the comment section of one of the videos. That's how I got a hold of her. Because I was able to like reply to one of her comments. And then I sent her a message or a comment a couple of days ago. I think sending her the link to the live and double checking to make sure she knew that we were over here on Crime Cafe. Um, and I haven't heard back from her, so hopefully everything's going well with her aunt. I think she said it was her aunt. Hold on a minute. It was a school reach call, one of those automated calls, letting us know that tonight's basketball game was canceled and the homecoming um, festivities have been delayed. That stinks. Homecoming is a big deal, you know? Let me see here. Tammy says, I'm confused about if this was the only court hearing and there was so much evidence lost. Judge said he's been hearing this case all these years. Why hasn't this case been dismissed? Well, you know, this isn't the only court hearing. This is his only trial. Now, the other guys, they did have, you know, their own, well, the Rory guy had a trial. I'm not, the other one, he didn't. There was a deal made, right? So, but the Rory guy did. There was a trial for him. I think Rory Wilson. Um, and the evidence lost was one of the biggest reasons why um, the captain and another person involved, I think an investigator or something, um, that Malone girl that was on the stand doing her testimony for a couple of days, they were both, on there. She was on there talking about it, and he kept asking her, about why she resigned and why she was like demoted, and it had to do with evidence. But there was apparently a lot of mishandling of evidence. So there's that part of your question, and then judge said he's been hearing this case all these years. Right. So, I mean, I'm assuming he was the judge assigned to this case whenever, you know, um, when when he was charged and all that. So I'm sure he's the judge that did all of the like pre-trial hearings. And so he's probably, already heard and known a lot of this. But as far as why it wasn't dismissed, I have no idea, unless the state really felt like they had enough for a conviction. I mean, you know. Let's see. Tammy says, yes, send her our love and prayers. Will do. Will do. Will do. Wonder what the reason was that he let lawyers go. I don't know. I don't know. I don't know what that was about. The only thing I know early on was I read or heard that he said something about lawyers being expensive and that he was being framed. So I don't know if the lawyers were like not believing his story or if he was just being too hard to get along with and they like he let them go or they like quit, told them to find themselves another lawyer. I don't know. Mickey says, what do you call? Oh, we got a joke. We got a joke. Hold on. Mickey says, what do you call a creative bank robber? What do you call a creative bank robber? A con artist. Oh, that's funny. Funny. Thanks for the crime time joke, Mickey Joe. Poor kids, says Tammy. You mean the basketball, the homecoming? Yeah, that's sad. Mm. I mean, the girls like have their dresses picked out. They had appointments to get their hair done, their makeup done, their nails done, all that stuff. Yeah, Don, he does clearly have to have the last say. Yeah. I feel he's a wee bit narcissistic. But I will say, I feel like he's done a good job for himself. Not that, don't get me wrong, he should have had a lawyer. I think anybody is goofy, crazy pants for trying to defend themselves, especially in a murder trial. He was, Tammy. He was fighting. I just feel like he didn't understand the process, like the judge was talking about with the judgment of acquittal and when the state or prosecution tries to rebut that, so. All right, let's see. They got Paula on the line, it looks like. Let's see. I think they're just going to be testing it out. We're not going to get our actual testimony because the jury is not there right now, so. Why would they wait to have the jury come in at 1 o'clock? That was. I didn't catch that yesterday when they were ending. I did not hear him tell the jury not to be there till 1. Did any of you guys catch that? I did not catch that. I heard him specifically say 9:15. And he said 9 o'clock, but then he's like, because you're always late, I'll give you till 9:15.
Yeah, go ahead and unmute it. Yeah, just push unmute it, and then push mute.
There's another button that she needs to push on her end that says play video, otherwise you're just gonna have a blank screen.
Okay. Do me a favor. The button, remember I showed you the button right next to it? It says play video. This should be like a little video camera. Well, for a second, just go ahead and push the video just so we see, okay?
When he's walking around like that, he's not in front of the mic, so you can't hardly hear him.
Not on the bottom? Calm down.
Oh, I can hear her.
That's all it says on the screen at all. Okay. Just go ahead and do that for right now. Just go ahead and say push. Just push where you say.
Yeah, Kel, but I didn't think it would take that long. I mean, the judgment of acquittal thing, that don't never take very long. I mean, and the judge said, usually no more than 15 minutes. He literally gave him 15 minutes.
Judge just wants to make sure everything's working.
And then the technical issue thing,
Got plenty of time.
you gonna give them 3 hours to work anything out? What are they gonna do for the next 2 hours?
Okay, communicate. See if you could get one of the nurses to help, okay? Oh, it's medicine time? Okay. Okay, so I'll tell you what, now, see if the nurse comes from your medicine. She's coming out.
I'm 2 cups of coffee in. I'm gonna have to go wee wee soon.
Oh, they got too many patients, is that what she said?
I didn't get up till I think it was about 8 o'clock, 7:30, 8. Oh wait, no, it was 7 o'clock. I think I got up at 7.
Plus, it's 10:14, but it's only 10:14, and we're not scheduled to do this so long. Is that what it is? Huh? What's up? We are.
All right, you guys, I gotta go pee. I got to go to take a pot tea break. I will be right back. Hold down the fort, folks. Don't burn the house down.
Like to take a break and take 5, as they say, and try to.
Oh, wow, literally. Perfect timing, right? Thank you, Judge. Thank you.
Understand. Okay, so.
And I'll tell you what, Your Honor, we definitely have it running.
Well,
I couldn't hear it.
you
Definitely what?
said we'll definitely have it running by 1 o'clock, but I don't want to. I don't want to wait until then. So.
Oh, okay. Were you gonna bring your jury in?
No. I just want to be able to see for myself that it's working before that time. So if that means 10:30, if that means 12:30, I mean, I just, what, it's kind of.
Hold on for a second, okay? Just relax. Just give me a second. Just give me. Okay. Actually, case management's there. See if they can help. Okay.
Judge,
See if they can help.
we're not in session, the camera's on. I would just ask for the camera to be off until we're back.
Oh, there we go. We got it. Got all of you.
What did you do? How did you do that? I just unmuted you. Okay, she unmuted me.
Okay, now go ahead.
I see a bunch of chairs in the courtroom.
Okay, that's good. That's good. That's what the jury is.
Okay.
Now we.
Oh, I see your head.
Now.
I see your head.
You see the flag? Okay.
I see your head, yes. Let me look. She's ruining my $1 cup of coffee. She's open. Oh, video buttons. Oh, here, start.
Yep. There we go. There we go. We can see now. Perfect.
We can see, we can't hear.
Okay, now we can't hear you now though. So no, we can't hear you, so you're gonna have to unmute it again. So yeah, she probably pushed mute by accident. There we go. Now we can hear you. We got video, we got audio, we're good. We can see. Hi.
The only trouble is
I don't see you, but hello.
Okay, hold on. Let's set the volume down just a little bit.
Okay.
Okay.
all right, so now I'm hearing feedback.
That's only because I have the phone here, so that's it.
That's,
As soon as I turn the phone off, it should be okay.
Okay, listen, anyone that comes in this room needs to be fully gowned. Gowns, masks, gloves, everything. Okay. Okay.
I've lost the picture.
Bye.
I literally just,
You did what?
I minimized the picture, that's all.
Okay,
Thank you. Thank you, James.
well, just,
I want to stand up for me.
Excuse me? Okay, so then presumably she understands it's gonna be a question.
But I still have on his laptop.
Understands that I'm gonna go ahead and ask my questions. The state's gonna get to ask their questions, and then I may do a redirect, we'll see.
And it's the middle of a trial and there's jurors present and.
She understands.
Okay, so you're satisfied it's good to go,
Oh my God, I can fall asleep just sitting there.
and apparently the state's representative is gonna need to be in certain attire,
We'll let them know.
so,
Hey, Paula, can you hear us?
Hello?
Hi, Paula, can you hear us?
How are you still there?
Because I'm still here because I'm coming through on the Zoom.
I'm not taking you away.
That's okay, no, you're good.
okay, before we recess, I just wanted to deal with one issue that's not to do with this.
Protest or whatever?
Yeah.
Okay, good. All right, Paula, we're gonna sign off for right now, okay? Just leave it just like that, and when we click on, I'll call you before we click on, or I'll text you or something, okay?
Okay, there's a woman coming to short-staffed this year.
Okay, no problem.
I'm taking them away from their nursing job.
Okay, no, I understand. Okay. All right, look, I'll go ahead and give you a call, or I'll
So
text
I'm
you
leaving
before.
it like wide open and just doing it that way.
Okay, and we're gonna have to lower that laptop or raise you up a little bit just so we can see it, that's all, okay? Because they're gonna want,
I don't even see them bumping or nothing.
okay, it's okay, you're good.
It won't breathe.
No,
I
you're fine.
don't know where the volume is.
Oh, I know, okay, because it's that table, right? Okay, when she comes back, get her to help you with that table, or just take the laptop and put it on your lap or something.
Hey
okay?
guys, I'm back.
Okay?
Okay?
Okay. All right, I'm gonna sign off for right now, though, so that.
I had the volume down.
I don't feel good and I just need to relax.
It's okay, you go ahead and relax, we'll be back in a little while, okay?
Okay, you might have to wait me out till 11 minutes.
No, you'll be fine, okay? You'll do just fine, okay? I'll go ahead and call you right before we sign on, okay? All right,
Okay,
I'll talk to you in a little while. Bye.
okay, thank you.
Mm-hmm.
Bye.
Bye, Paula.
Okay, so
I'm just gonna go ahead and mute this, Your Honor.
I understand. Guess we have as much assurance as we can hope for in terms of everything being ready to go. I was just wondering if you had any other evidence that you were planning to present after her testimony is complete.
To be honest,
He does, Don, right?
it probably wasn't gonna be worth it. I was like, I don't know how long it's gonna take. I didn't know if there was gonna be any issues. I figured just on this caution. I was like, because I do have some other witnesses I'll be bringing on Monday. So I just figured, with her going on, and again, I don't know how long, just her breath, she may need breaks, whatever, I don't know.
All right. Okay, so what? 12,
We'll be here 12:45? I think you told the jury 1, is that right?
yeah, I
Judge?
told the jury 1, so I'm not sure what we're gonna do for 15 minutes.
We'll be here at 1, how about that?
Well, about 12:55.
Perfect. All right, sounds good.
All right.
Judge, just to, so we're clear, as far as our investigators attire, I think Mr. Mansfield and I are in agreement that he doesn't necessarily need to be in the room with her. He just needs to be outside the door to make sure no one else is in the room with her, coaching her while she's testifying.
Whatever you want within reason, it's your representative. So if you would prefer that, or it's okay that he's not in the room and all gowned up and everything, if that satisfies you all, and he just wants to be at the outside, that accomplishes your purpose, okay.
Thank you, Judge.
All right, see you at 12:55.
All right, 12:55. Let me write that down. Let me write that down so I don't forget. Court back at 12:55 for Miss Paula. All right. I agree, Kel. She's going to be hard to understand and hear. Yeah, I agree. Apparently she's got COPD and has like a hard time, and she's hospitalized at the moment. So Tammy says they're really going to try to make it sound like he bribed her to say he didn't do it. Possibly. I hope the prosecution isn't hard on her. The investigator shouldn't be in her room. Yeah, I feel like that if he were in the room, the investigator, I feel like that would be like I would feel intimidated, you know? Um, so I don't know. I do not know. Don't know. Well, you guys, I think I'm gonna jump out of here. It is 10:30 almost. So 2 hours will be when it actually starts. So I guess I'll just break today up into a couple of different parts. And start back at 12:50-ish. Husband is supposed to be home from work early today. So I'll give us all a couple hour lunch break, so to speak. And so yeah, I do too. I need to take a shower. I haven't had a shower yet today. I wanted to take one this morning, but did not happen yet. So I want to take a shower and get some other stuff done. Wait for husband to get home, and then see what his plans for the day are. I think he was going to take, like I said, kiddo out to play in the snow, so that ought to be fun. But thanks, guys, for watching and being here with me this morning. This was a pretty interesting argument this morning. Cool to see. Here for it. Please give the video a thumbs up before you skedaddle out the door. And I'll see you guys back at 12:50-ish, okay? Eastern Standard Time. All right. I love you guys. Bye.